Clause 36, Amendment 53J. Lord Moylan.
My Lords, we're back now on the Transport and Works Act, and this amendment, or the clauses that we're dealing with here, this particular clause, relates to the holding of an inquiry when Transport and Works Act powers are used. So, since it will come up at some point later, it's worth just reminding noble lords that, I'm sure they know all of this, that for major construction works and infrastructure projects, there are three methods available to a promoter for getting permission. One is planning permission from the local authority. One is to go, since 2008, for a development consent order. But for some time before that, when I say three, there are really four, because there's also a hybrid bill. But there's also this intermediate thing of getting a Transport and Works Act order under that statute. And in doing so, of course, one impinges almost inevitably upon the rights of others, the property rights of others. And so the possibility of having objectors and the possibility of holding inquiries in order to examine those objectors must of necessity arise. And that's the part of this that we're dealing with. That's the part of the Transport and Works Act that we're dealing with. There are two things going on in the bill that, as far as I can make out. One is that it's currently the case that if somebody wishes if somebody raises an objection, the Secretary of State may hold an inquiry, or they may appoint somebody to hear the objector. However, they don't have to appoint someone to hear that objector if the Secretary of State considers that the objection is frivolous or trivial. So there is a seriousness test, if you like, before the Secretary of State is obliged to respond to the objection by appointing someone to hear it, or indeed by holding an inquiry. One of the things happening in the bill is that seriousness test is being changed, so that it now has to be something considered serious enough by the Secretary of State. No longer the very low bar of trivial and of frivolous and trivial, which are terms actually quite well understood, I believe, in legal circles. Now it becomes and therefore testable to some extent objectively. Now it becomes an entirely subjective test on the part of the Secretary of State as to whether it's serious enough. Enough for what? No definition is offered. And I think this moves the balance of power away from the citizen and in favour of the promoter, who is very often the government, in a way that deserves inquiry. So that's what these amendments are intended to highlight and invite the government to comment on. In addition, there's the question of whether the government has to hold an inquiry or appoint a person. At the moment, in the Transport and Works Act, it is may do so, but with the rising of the seriousness test, if that is admitted on the one hand, then it seems to me that if someone passes the seriousness test, then it should be must hold an inquiry or appoint a person on the part of the Secretary of State. After all, if it's admitted that the objection is serious enough, surely it must follow that enough for what? It must follow that an inquiry should take, or a hearing should take place. So I'm trying, again, not unhelpfully, to get, if we're going to have a different balance, let's try and get the right balance. But it would be worth hearing what the Secretary, what the Minister has in mind here, and whether there's any give on his part. Finally, I turn to my Amendment 53L. This relates to what as far as I can make out, to be a new power of inspectors. These are at Transport and Works Act inquiries, not planning inquiries, but specifically Transport and Works Act inquiries. An inspector to impose costs on those who appear. Now, at least in the planning realm, with which I'm more familiar, inspectors can indeed impose costs on one side or the other, and in some cases on both, but only if there is some sort of delinquency on their part which has caused damage and held up the inquiry. Failure to provide documents on time, not turning up at hearings, that create costs for the other side. The inspector can hold a separate costs hearing and can and does impose costs. I think we'd all agree that's a sensible measure to try and minimise delinquency on the part of those attending hearings. But a general power to defray the costs of the inquiry could have a chilling effect on objectors. Now, that may be the government's intention. It may be that the government only wants the well-heeled to be able to appear before inquiries. If so, I think it would be as well to say so. But if not, then I think that this new power, I think, needs to be either removed or very severely moderated. And with that, my lords, I beg to move.